It was then gathered that the rules adopted by Napoleon Harris required that caucus candidates shall only be nominated as a slate of candidates for all open positions for each office. This is a clear violation and disregard of Libertarian Party. What? Seventh Circuit. I probably should have. If I would have gotten this sooner, there's a few things that I would have looked up because now I want to look up that case. Okay, this is a clear violation. Now this is getting interesting because if these are accurate, I'm not saying they are, but if these assertions are accurate, hey, she might get another dub on the case related to this in court. This is a clear violation and disregard of Libertarian Party of Illinois versus Schultz, a federal circuit case which ruled that requiring a full slate of candidates for nominee purposes is unconstitutional. Oh man, if that's accurate, I'm gonna have to look that case up. I might do it before we get off here. I don't know. I got a movie to finish with my baby girl. That's a big fucking deal though. Like that is a very, very big deal if that's controlling precedent is actually applicable in this jurisdiction. If that's the case, game, set, match, she gonna get a do-over. Like I don't want to be the bearer of bad news, but if that is the case, and that case is, you know what, man, fuck, I can't not look at it now. It's gonna bother me. Hold on, this is about to bother me. Let me see. Give me 1 second. Let's see. Libertarian Party of Illinois versus Schultz, 872 F third 518. Oh, let me get to the bottom. That's not looking good. Let me see. The full slate requirement severely burns fundamental. God damn, I'm not about to read this case. this case long as shit. Hey, my bad, yo. This case is long as hell, but let me see. Let me see. I want to get to the holding of the court. Let me see. The full slate requirement, the only one of this kind in the country, severely burdens the First Amendment rights of minor parties and their members, and it must be narrowly drawn to advance the state interest to a compelling import. That's some legal standard work. Illinois emphasizes that these interests are served by reserving the ballot for parties with at least a modicum of public support. No one doubts that Illinois' stated interests are compelling in the abstract, but the full slate requirement doesn't advance them. By creating unwanted candidacies, the requirement, as Illinois would tell it, the requirement egregiously set minor parties into two camps: those that have a bunch of ready candidates for every race and those that don't. But like other laws, the full slate requirement shapes the behavior of those it binds. Whatever is it aims, the requirement forces a minority party to field unserious candidates as a condition of nominating a truly committed candidate. The Libertarian Party, for example, might have filled 6 other Kane County slots with Fox friends or relatives. In reality, then, the full slate requirement does not ensure the only parties with a modicum of support reach the ballot. Instead, it ensures that only the minor party on the ballot are those that have a strong public support or are willing to find enough frivolous candidates to comply with the law. Hmm. This is actually interesting. Like, I don't know. Like, all right, so damn man, I may have to do a live breaking down this case. This is actually interesting. So essentially, the Libertarian Party was in this lawsuit because they like, yo, we're a small third party. It's unduly burdensome for you to say, yo, in order for us to even participate in the electoral process, we need to have seven motherfuckers. We need to have seven people. My bad. I got at certain curse words I try not to let slip. But we need to have seven people on the ballot. That's hard for us to do because we're a small party. We can't do that. But we do have a viable candidate for this one seat, which I think is a good argument, actually. And so the court is saying that the full slate requirement severely burdens the fundamental constitutional rights and is not narrowly tailored for compelling interest. So that's going to be interesting because I already see where this is going to go, right? Again, hey, I just looked up at the comments. Shout out to co-counsel right here. Co-counsel right here. I about to say you said exactly what I was going to get at. I already knew what the argument was going to be, and you hit the nail on the head. Shout out to y'all, co-counsel. Y'all in the chat doing y'all thing. I know I haven't been looking because there's so many of y'all in here tonight. But y'all been in the chat doing y'all thing. But you made a great point. So the argument to be made is that that applies to a third party. The Democratic and the Republican Party are the only two really viable parties. The court's opinion in that case doesn't burden the Democratic Party because they aren't a small third party. So, as one of the only two main parties in any essential municipality, you should have more than enough viable candidates. So, I think that one, I'm gonna just be honest. I think is a great fucking argument. I think whatever. Shout out to Max Solomon. I know he was disbarred and rebarred again. Shout out to you for complying with those things, but shout out to him for drafting this because I think that's a good argument. But I do think that that argument is not going to be a successful argument for the exact reason. You can see just in the very few sections that I read out loud, the court's focus was on the slate requirement putting uh a small third party uh at a disadvantage because they don't have a lot of viable candidates to fill a slot. So I think that argument won't be a strong argument considering that she's registered as a Democrat. Now, if she was registered as like the Blue Party or the Boston Tea Party, that shit might be she might have knocked it out of the park personally.